or own property, or rent property, which is a sort of a indirect way of paying rates, and we'll come to responding to the Minister's comments in the district plan review. But I wanted to begin by asking a question that I was asked to put to the team on behalf of the community boards yesterday, because we had our community boards council meeting yesterday, and we were specifically asked whether they could make submissions directly to the hearings panel when the district plan is notified. And it was certainly my view that nobody wants to stand in the way of community boards making submissions, but also we didn't want to have the situation arise where people were inadvertently cancelling each other out by sort of potentially putting both sides of an argument, but from different perspectives. I think that the community boards were very keen that their individual wards were focused on in terms of the different chapters that might impact specifically in their areas. But doing that within perhaps an agreed framework with the wider council might actually be a better way to go. So I've invited Ian Thompson as our legal advisor to give us a response on that.
Thank you. The essential point is that community boards have been established and have a role to represent their communities. It's an internal focus rather than external. So if there was an internal council process, community boards would be perfectly at liberty to make individual representations. This is an external process, and the accepted advice that has been long-standing now for some years is that yes, community boards can submit externally, but only with the delegated authority of the council. So it would be up to the council to determine whether or not they wished community boards to submit separately in their own right. And it appears in this particular case, and picking up the points that the Mayor has made, that there are probably advantages more in having the community boards feed into a council representation than being given the authority to submit separately.
Can I just remind me what the time frame is for submissions to be made? So we notify
on the 27th of this month, and it's open for 30 working days, and then we publicly notify, we make available to the public the submissions, and then it's open for further submissions again on the 23rd of October for 10 working days.
So the idea is that people will be able to see what the submissions are that have come in.
Absolutely.
And then have another chance?
Yes.
Do you already have to have submitted to submit the second time round?
Yes.
Because I think that's quite important. So really we've only got a month from the week after next.
30 working days, yes.
Yeah. Oh no, so
4
it's
weeks.
more than a month, it's about
Yes.
6 weeks, yeah.
Yes.
So given that, I wonder whether it would be appropriate to have a joint workshop between councillors and community boards in order to discuss the framework for submissions. But, I mean, what I want to do is try and make this as open as possible, but and this is some of the concerns that we have as a council. We're particularly concerned around intensification in some areas, urban design, accessibility, sustainability and notification. Now, the position that we're adopting on these is, I think very positive. It's what our communities want. But if others make submissions to the hearings panel, and we're not in a position to respond in a very strong way to defend, what we have promoted, then we feel that we will not be providing the best representation for our communities. So, and I know that a lot of the community boards feel exactly the same way, and that they want to be engaged in that process. But we also don't want to end up undermining the strength of our position as a council by having our own community boards inadvertently put in a submission that might undermine one of those. So, so the question is a joint workshop in order to discuss those parameters. Phil?
I think, given everything we've heard, that sounds like the best process. Do we need a formal recommendation on that, or can that just?
I think it can just happen.
Yep.
I was just consulting with legal counsel. I don't think that's a problem for us to go over what is in the plan and for everybody to understand what is in it and for you to hear what the feedback is from those community boards. Are you saying it would be a joint meeting between the council and the community boards and officers would simply go through what's in the plan? Is that what you're expecting?
The idea is that we need to be alert to what our priorities are. And what we're concerned about is that people will make submissions to the plan. I mean, some of the comments that have come through from the Minister would see us reduce our focus on urban design, accessibility and sustainability. So we must assume that the ministers themselves will submit on the plan to reduce those obligations or guidelines in the plan and maybe even increase the levels of intensification in some areas where we don't want to see intensification occur and our communities don't want to see it occur. So, you know, given that, we want to be in a proactive position so that we make a submission that really defends our position so that if they do make a submission themselves or others do, and we can assume that others will, that we're in a position to, you know, sort of push back with an even stronger submission to the independent hearings panel.
I understand. Yes, and yes. Yes, you can do that, is my understanding, and yes, we're happy to participate in such a forum.
Great, that's fantastic. So that's the approach that I think councillors will be happy with, that we will organise a joint workshop with our community boards so that we can establish what those priority areas are and work on a submission guidelines. But I think that whether that we can make sure that each individual community board is able to show what their areas of concern are, because if that can be reflected in the council submission, then I think that would be good. But if not, then we would have to look at a delegation for a specific area to make a submission on their own behalf. Ali?
Just two things really quickly. Firstly, what does that do to any time frames with regards to progressing the district plan? And secondly, when we, because I think it's a great idea, perfect, when we include and involve and invite the community boards in, from personal experience being involved in this process, it's not overwhelming or daunting, but there's a hell of a lot of information there. Is there any way we can provide them with a précis or something that gives them a foundation or position to come from? Because if they come in where we did with what we've been told, I can see it being quite overwhelming and time-consuming.
You don't think sending them this
No,
would do
I
the
don't
trick?
think that's probably the So time frames and just whether we can give them something as a kind of a précis.
No, I think a précis around our priority areas. I mean, I've identified intensification in some areas, not all, but urban design, accessibility, sustainability, and notification. And by notification, I mean that there are certain activities which must be notified publicly, and that's something that our communities feel very strongly about, and not having them made on a non-notified basis.
Just in relation
no,
to
it
time
won't
frames?
affect timeframes. No.
We would have to do it though, obviously, sooner rather than later, so that people are prepared for that 30 working days. I mean, it can be done after the 27th, but it would need to be soon after that. So we would need to get that in people's diaries.
If we change the deadline that was communicated to us for submissions,
it can't change the deadline.
No, I mean the submissions that were invited from the community boards. My recollection is that the deadline was today. Have I misunderstood an email that's gone out?
No, there were no comments from community boards or anything like that. That was done some time ago when it came back to you and you considered what changes should go out there before the copies went to the ministers.
But the one thing that I just wanted to clarify was that we had to make a preliminary submission in order to be able to make a counter submission. Yeah. David?
Just on the position of community boards making a submission and having a joint workshop, there's always sort of been the problem of the community boards having a different perspective from the council as a whole. So how do we overcome that if, say, a community board has a different perspective on, say, the natural hazards than council may want to have as a whole?
Well, the point that we're making is that if we'll have a joint workshop to look at the priority areas and how establishing guidelines for those, hearing from the individual community boards as to their priorities. But we will not be delegating authority to individual community boards.
No. So what happens in the case of a community board has an opinion that's at difference to council? Does that then have a fallback that an individual community board members would then have to make a submission on their own behalf?
Well,
an individual,
anyone can make a submission as an individual,
but they can't make
it as a community board member or on behalf of the community board. Yep.
Which sort of
So, all right. So, Yanni?
Thank you. Have we been given a briefing on the order in council?
No, you haven't been.
So I just think it would be really helpful because the order in council is basically what's driving this process, and it's been through Parliament, but we actually haven't been given the details of what it means and how it's going to work. Is it possible to get an understanding of the key elements of it in terms of what it means in terms of this process?
That would be appropriate if you want to just quickly run through it.
It's in the public realm. Would you like to do that now?
Yeah, might as well.
Are you okay?
Okay, so what the OIC does is it modifies the normal process under the RMA. There are a couple of key points to raise at the start. What it does is it takes away rights of appeal to the Environment Court, and only appeals on points of law are available. That's one of the major changes. What I think would be best if I just walk you through the more important changes. So the OIC stipulates a number of timeframes. The first one, which we've already talked about, is notification for the first set of first phase of proposals on 27 August. That date is non-negotiable in the OIC. We then have the normal process where we have submissions, 30 working days, and then we have the allowance for further submissions. That is as already provided under the RMA process. I think if we take a step back, and the reason we're here today is that there's a unique step in that after you gave a decision back in June to send the draft chapters to the ministers for their comment. And so what that means for this meeting today is that it's an extra step in the streamlined process where you are to consider the recommendations prepared by the council officers on the ministers' comments. What this means is that you have to have particular regard to the ministers' comments, and I'll come back at the end as to what that means in terms of your legal requirements to do that. So after notification, the OIC allows for a number of pre-hearing processes. These are similar to what you would get in a kind of board of inquiry type call-in process, and they consist of pre-hearing meetings and mediation and alternative dispute resolution. The OIC places quite a big emphasis on these pre-hearing processes.
Sorry, can you repeat those 3 things?
Pre-hearing meetings, and they will be chaired by one of the hearing panel members or by someone else who the chair delegates that role to. There's also mediation, so that is similar to what you have under, for example, Environment Court type appeals, and then alternative dispute resolution. So the power sits with the the chair of the hearings panel to direct that they happen. So we have the hearings panel, the independent hearings panel. The Order in Council appoints Sir John Hanson to be the chair of the panel, and the ministers, in consultation with the council, will be appointing the remainder of the panel. It is a minimum of another 3 decision makers to be, but there can be more because the OIC allows for a split panel, which would essentially mean a minimum of 6, so the chair plus another 5. So the Order in Council has another quite important date in it, and that is that the decisions on priority matters have to be made by 20 February 2015. The priority matters are not the Phase 1 chapters, but they will be as set out in the terms of reference, which will be prepared by the ministers, and we do not have them yet. So at the moment we're not sure what the priority matters are that will need to go to hearing between now and the end of February 2015.
Is there a deadline to receive that?
There's not an Order in Council, no.
There is one that could change. I mean, there is a provision in the Order in Council that date could be changed by agreement. But it may well be that the terms of reference could simply require that the first of the chapters, the strategic directions chapter, be determined by then, and then the others could follow. Because it is an incredibly tight time frame, and I think somebody forgot that Christmas, and most people take their holidays over that period. And it may well be that actually having the strategic directions out there as the basis for the hearings on the balance of the chapters might actually be a better process anyway. So I would imagine that there will be a bit of discussion to and fro relating to that.
What's our process for agreeing the terms of reference?
There isn't one.
There isn't one set out in Order in Council.
But have, surely government or someone has given us an indication of how we're going to come up with it. I think we consulted on the terms of reference, so what's the process for that?
The ministers have to, they do have to consult the council in terms of the terms of reference.
Right.
I'm not sure of how that process will roll out.
So they've just written us a really critical letter, but we've got no idea about how we engage with them over the terms of reference. They haven't given us any information on that.
Not at this stage.
It's just, okay.
I guess the key point there is that the terms of reference might just be the strategic directions that need to get sorted out by February, and that would be a fantastic grounding to move the rest of the decision making and hearings forward. The OIC provides that the rest of the chapters, whether they're notified in Phase 1 or Phase 2, if they're not a matter of priority in the terms of reference, decisions don't have to be made until the date in April 2016 when the OIC expires.
I'm really interested in this is that actually if we wanted more time, because one of the reasons that we've rushed to get this ready was because of the tight timeframes. If there's more time available to have more conversations about some of the key issues that we're concerned with, then I would like to do that. But I've understood all along that we haven't had the chance to do that because of the tight timeframe. Now I'm hearing that there's another process to work out what's going to be done first, that we don't know what that process will be, and it might only be a small part of what we're about to adopt or publicly notify today, or it might be a whole lot.
No,
So
everything would be publicly notified that is before you today on the 27th.
Everything.
And this is the terms of reference is just about which aspects of all of those chapters will be
Determined
heard and
by-
determined by February.
By February.
That's right.
But there would be no... okay.
And I suspect the reason we haven't got into discussing the terms of reference is because they're busy at the moment setting up the hearing panel and determining who the rest of the members will be of the hearing panel. And I suspect, this is just my thoughts, that the chair will want to have his panel with him to determine and talk about those terms of reference with the ministers. And then the ministers with us.
Yeah, I think Brigitte is right, because the time frame was in part dictated to us by the advice that we received from staff, Yanni. So it wasn't just a question from the minister, because I remember us having debates about the Woolston chapter and various other things that I wanted to pursue. But the idea that we get the 11 chapters into the public arena for the first tranche doesn't mean that that decision-making process has to be restricted to those 11 chapters, because in fact if we said that if we agreed with the government that the terms of reference would be that they had to have their hearings and make determinations on all 11 by the February date in the Order in Council, it just would be impossible. They'd have to sit through Christmas, New Year. Nobody would be going on holiday. I don't think our staff would appreciate that either. So I'm very relaxed about the fact that the government will come and talk to us about the other members of the committee, and they will come and talk to us about the terms of reference for the hearings panel. And I think, we have a small group that were given delegated authority to work on the aspects related to the land use recovery plan, and I expect them to be involved in that process. But we certainly have been very open with government, and they've been very open with us both ways, and I'm satisfied with where we've got to. But no, there isn't more time available, and no, we wouldn't have been able to hold back chapters, because there is another tranche of chapters which our staff are going to get on with as soon as this lot are notified.
Indeed, they're already halfway through, and we hope to come back to you at the end of this year or in January next year with them. January next year.
She said.
After Christmas.
She said hopefully. What we'd like you to do now, so thank you for that, and staff have already started setting up the workshop. Yep.
Had finished on the Order in Council, but if you are, there's one question I really want answered is, what is a statement of expectation in legal terms, and how does that relate to decision making over this? And is that something that we have to adopt as a council, or is it something that's separate, and what's its function within the Order in Council?
Sure. Okay, so the statement of expectations it's included in the Order in Council. As part of the Order in Council requires the council to have particular regard to the statement of expectations as it reviews its plan and puts forward proposals for notification under the Order in Council process. The timing of the OIC means that there's an extra clause in there that says that the work that has been completed to date essentially has been processed as if the council was having particular regard to those statement of expectations. But part of that means that the minister's comments that we've received have focused back on the statement of expectations, and that's allowed for in the Order in Council. In terms of the relevance to your decision making and today, so the council, and this is what the officers have done, is they've prepared their recommendations to bring to you, is that they have, as well as having particular regard to the minister's comments, they have also had particular regard to the statement of expectations. But at the same time, the statutory tests in the RMA, Section 32, and the council's functions and what it must have in the district plan, they are also relevant statutory tests which the officers have been considering at the same time. So the statutory testers have particular regard to. Obviously there's no case law on what that means, because this is the first time we've done this. But we've taken guidance from some other case law under the RMA that uses the same terminology. And what we can bring from that is that the written comments are important to the particular decision and are therefore to be considered in substance and carefully weighed in coming to a conclusion. The matters raised in the written comments must be given material consideration, but they are not standards that must be fully met, nor criteria that have to be fully satisfied. The council has a duty to have an open mind and be on inquiry, and what that essentially means is it cannot just disregard the comments as irrelevant, but must give them due consideration. And you'll see in the officers' recommendations that they have a reasons column, and that clearly sets out their view and their reasons behind the recommendation they have made to you on each of the 29 recommendations that have come from the ministers, as well as the comments, because there's another number of paragraphs that sit within the recommendations. So the officers have looked at not just the recommendations, but also each paragraph and linked it in with a recommendation.
Like if I'm a submitter making a submission to the hearings panel, and I say I want, if there's something happening in my backyard or across the road, I want to be notified, and the statement of expectation says we shouldn't notify. We should significantly reduce the need for consents and the requirements of notification. What does the hearings panel?
The hearings panel has to have particular regard to the statement of expectations in its decision making.
Yeah.
Which means that.
Which says to reduce significantly compared with the existing district plan. So the phraseology is somewhat ambiguous in its own right.
So the same, I mean, it has to have particular regard in the same way that the council does. But I think you have to remember in a holistic view of this that there are a number of relevant considerations that have to be taken into account. There's also the other statutory tests under the RMA that are also relevant.
And just, the final point on the statement of expectation, which I'm struggling to understand, is we didn't know the statement of expectation when we prepared this first phase to be publicly notified. So how could we have regard to it? And I mean, given that the government's attacked us quite critically about our thing that's been prepared, yet we hadn't even got a copy of their statement of expectation, how can we, how can we say that we have taken it into account and had regard to it when we haven't?
Well, yeah, so that's why as this part of the process, we have had particular regard to the statement of expectations in our response to the Minister's comments.
But we've had 3 days and our whole plan's already been prepared, and we've had 3 days to give effect to a statement of expectation.
Yeah.
No.
I would make a
The statement
comment.
of expectations was known when the document was scheduled, 7th of July.
That's right.
That's been publicly notified since the 7th of July.
And aspects of it we were well aware of through the CCRP process, for example, and through discussions with the ministry's staff as well. For example, streamlining, balancing flexibility and certainty, and those particular principles were not new to us, and we have been applying them all the way through.
I don't think this council ever decided that our district plan would significantly reduce notification requirements or urban design requirements. In fact, I thought what we'd done, it was quite the opposite, where we'd had community feedback.
This is really helpful, thank you. What we have done is actually shown where these significant reductions to our existing districts compared with the existing district plans. We've got 2 plans that we're merging. So I think that what staff have helpfully done is to meet the objectives set out in the statement of expectations, perhaps not in the way that the ministers fully expected, because that's come through their comments to us.
Yes.
But at the end of the day, the hearings panel will decide what that will be. And we have said very clearly that the plan we have produced meets the statement of expectations. And I want to stand by that, because ultimately that will be determined by the hearings panel. And I'm hoping that, and I mean, we can't influence from comments that we make here, but I'm hoping that we absolutely stand by what we have sought to achieve in that regard, because we have our community expectations to meet. And now that we have the minister's comments, it is clear that they wanted to go further then we felt that we needed to go in terms of meeting that statement of expectation. So I think that's what we're here for today, is to really go through the responses that we're going to make to this particular document in order to meet the concerns that the ministers have raised, but where we are basically pushing back, and we are going to push back in certain areas, we are making it crystal clear that we've taken on board their comments and why we would be not picking up the particular argument that they've put forward. Ali.
I wanted to ask about the reference to there not being case law when you were talking about justifying a position that's taken and arguing one's position. I may have misunderstood, but it sounded as though you were using that as an example from which the council's position would come from. Does that apply to the ministers and the government as well? Are they under an obligation to justify their position based on other cases that may have been presented in similar circumstances? Am I being clear?